Good morning. Are you Garson Mendoza?
No.
And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with?
No.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter? And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you're waiving any right to appeal? And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
The courtroom begins with a simple question, but the charge behind it carries serious weight. A first-degree felony. Aggravated robbery. The defendant stands before the judge and pleads guilty, freely and voluntarily, admitting responsibility for what happened. Documents are reviewed, translated, and confirmed. Rights are explained and knowingly waived. The agreement is laid out clearly: 10 years of deferred probation, a fine, and strict rules that must be followed. The judge confirms competency and understanding, then finds sufficient evidence to support the conviction. But judgment is not finalized today. Sentencing is reset to allow for a full pre-sentence investigation. As the hearing pauses, one issue remains unresolved: the question of bond hanging in the air as the court weighs the seriousness of the crime against the path forward.
Yes, ma'am.
And state tenders number 1,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to a bond based on the nature of the...
The judge listens, but age alone is not enough to change the stakes. 18 years old. A serious charge involving robbery and a weapon. The bond remains untouched. The court decides to wait for the pre-sentence report before considering any path forward. With that, the defendant is escorted out. Moments later, another case takes the floor. A young man facing a state jail felony for theft of a firearm. The pre-sentence report is reviewed carefully. Accountability becomes the focus. The court makes it clear probation is not about excuses, but honesty. You either committed the offense or you didn't. This is the moment where opportunity meets truth. When asked directly, the answer is simple and final. He admits it. He did it.
He's 18 years old. Several classmates that
I can't hear you.
I think he was less culpable than the other defendant, or co-defendant in this case.
I'm not going to change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young. So let's just see what the pre-sentence report says.
This moment in court is pivotal. When a defendant admits, "I did it," it's more than honesty, it's a strategic choice. Judges in probation cases value accountability over excuses. The message is clear: probation is an opportunity, but only if taken seriously. You must be open and truthful, or the system will quickly close in. Any attempt to minimize responsibility or hide issues leads straight back to harsher consequences. Mr. Reed understands this. He entered his guilty plea freely and voluntarily. The court finds sufficient evidence, sentences him according to the agreement. 5 years of probation, a $1,000 fine, $1,500 in restitution, and adherence to all rules and conditions. Follow the rules, stay honest, and this chance can set him on a better path fail, and the consequences
All right,
are
so you
immediate.
can go back with the bailiff. Thank you, Ms. Parrish. Good morning. Are you Deontay Wayne? Or Deontay Wayne Reed, I'm sorry. And Mr. Reed was previously in court and cause number 240838. Entered a plea of guilty to the state jail felony offense of theft of a firearm. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yeah, Judge.
State has, Judge, I suspect it's something on page 1 of the court.
I-
I have.
Mr. Lewis?
Yes, ma'am, Judge. I've spoken with my client about this, as far as his assessment of accountability and for his admission to this offense. At that time, I could tell you, Judge, after speaking with him, he understands the issue with that as far as his making a decision to.
The judge drives home the reality of probation. It's a second chance, but one that comes with strict limits. Mr. Reed will serve his 2-year sentence while out on probation, not in state jail but any violation, and that opportunity vanishes instantly. He must also earn his GED and follow all rules, including mental health treatment if required. There's a detail many miss. A felony conviction permanently removes firearm rights. Violating that can trigger new charges. No warnings, no grace. The court emphasizes that all these conditions are meant to help him build a better future, safer, legal, and productive. Certification and written admonishments are handed over, spelling out his responsibilities and rights lost. One choice remains clear: follow the rules, or the consequences are immediate.
Try to get probation, as he's talked about here in the PSI. That this would involve him not just taking responsibility, but being honest and truthful about his plea, whether he was guilty or not guilty. And of course, at that time, explaining to him that way, he's prepared. He's prepared, of course, to truthfully admit to his involvement in what he did in his offense, which he says he did commit this offense at the time.
So you either did it or you didn't do it. And so